Good afternoon. I want to call the Committee on Higher Education to order. I'm Senator Donna Mercado Kim, Chair. Our Vice Chair is Senator Michelle Kidani, who should be coming, and the other members of the committee. Today is Thursday, January 18th. We're in 3229, and it's about 3:32 p.m. And I want to thank all of you for being here. I know this is a little unusual, but there have been a lot of concerns raised to me regarding the Sunshine Law, how it's being applied, how it's being interpreted, and how in some cases it's maybe impeding some of the work that needs to get done. And in light of that, I thought it'd be great to have those that are interpreting the Sunshine Law, those are affected by the Sunshine Law as it pertains to higher education and the university, because that's my purview, to have this discussion and see, in fact, if there is areas in which their interpretations may have been overzealous on the Sunshine Law and maybe not enough. I'm not sure what it is, but again, that's why we're all here. So I would like my staff to pass out to you. I did some research on the internet, and I did find the Sunshine Law from the City and County of Honolulu, and it has some basic questions in there, and I thought it'd be a good place to start at first, at least. It talks about the law itself, and it talks about defining what board business is and so forth. So I think this would be helpful in guiding us. But before we even go to that, I would like to then ask our Attorney General perhaps to say some words, ask our OIP and General Counsel, and then maybe we can get into some discussion.
I'm not sure what words I want to say specifically, because frankly, I hadn't thought about it. But what I want you to know is that OIP, Carrie, and my office speak regularly about these issues. We call OIP when we have questions, and we have good conversations about that. Carrie and I regularly call each other. I have my expert Stella Cam here, who has been the expert in Sunshine for I don't know how many years at the AG's office. We did meet yesterday. We talked about these issues, so we're prepared to have a conversation and answer questions.
Wonderful, and thank you for bringing resources also to assist. So with that, Cheryl, you want to introduce yourself, please?
Okay, I'm Cheryl Kakasu Park, so I've been the director of OIP ever since former Governor Neil Abercrombie appointed me, thank you, Governor, in April of 2011, so 13 years there. But I'm not the longest serving people, and that's why I brought Jennifer Brooks and Carlotta Amarino, who are really the brains behind everything. They've been with OIP like going on 50 years or so. So I just want to say that I do appreciate working with people in a collaborative manner. We try to help everybody, and that means everybody, because the Sunshine Law applies to, as you know, all Sunshine Law boards, which are most of the boards in the state, at the state or county level. And we also administer the UIPA, the Open Records Law, which applies to everybody in the executive, legislative, and judicial branches of government.
Except us.
Well, UIPA does apply to you. The Open Records Law does. Sunshine Law doesn't. Right. So Sunshine Law does apply to the county councils. So we try to do our job by proactively, by hoping to prevent violations before they happen, because we are overloaded when it comes to trying to resolve disputes once they rise to the level of an appeal. And so we put a lot of resources into our training materials, which are online now. So people, including the general public who don't have attorneys to help them out, can go online and understand what both laws require. And both laws have the same declaration of purpose or policy, but they are actually quite different from each other. One thing about the Sunshine Law is that it does tell us, everybody, that its provisions are to be strictly construed against closed meetings and to be liberally construed in favor of open meetings. So if there's ever a question, we have to kind of lean towards openness, and so if people think we're being too strict, I just have to go back to the law and said, well, we're just doing our job. This is what the law tells us to do.
Right, but then you got to interpret what open means, right? So,
Right.
Carrie, are you done or?
Yeah.
Okay, Carrie, did you want to?
Senator, thank you for holding this briefing. I just have to give a lawyerly caveat because although there are less than a quorum regents here, we haven't really taken a position on any legislation or anything like that. So I'm really speaking on behalf, and then Sunshine Law doesn't apply to administration. So I'm really speaking kind of as myself for that, what that's worth, and if that's okay with the senator.
Yes, absolutely.
So been a government lawyer for a long time, for the city council as well. So the Sunshine Law was always something we could navigate. And I think what you're seeing here today is that it's become harder to navigate. And the difficulty is, and I think this is really key, is that a lot of the boards and commissions are not lawyers. They are lay people that are supposed to represent through appointment and confirmation the interests of the public. They are the public's designated representatives, for lack of a better word, for what the oversight over that department's going to look like. So I think that's really important to note. And you shouldn't have to be a lawyer to serve on a board or a commission. I don't think that was the intent. Thank you. Happy to respond to any questions.
Okay, let me just go over, and I've given everyone a copy of this Sunshine Law, and they're kind of basic on it. But let me just, to start off, and then we're going to ask participants who have found that having the law is one thing, how it's applied and how it's actually interpreted as far as them doing business, what are some of the pitfalls in that. So basically, the Sunshine Law is Hawaii's open meetings law, and it generally prohibits discussions about board meetings between board members outside of a properly noticed meeting. And the purpose of it is to opening up governmental process to public scrutiny, and participation is the only viable and reasonable method in protecting the public's interest. Therefore, the legislature declares that it is the policy of the state that the formation and conduct of public policy, the discussions, deliberations, decisions, and actions of governmental agencies shall be conducted as openly as possible. To implement this policy, the legislature declares its intent of this part to protect the people's right to know. The provision requiring open meetings shall be liberally construed, liberally construed for open as possible. Again, that's got to be interpreted. The provisions providing for exceptions to the open meeting requirement shall be strictly construed against closed meetings. Okay, this is an open meeting, so are we violating the Sunshine Law? The provisions requiring open meetings or the exceptions to open meeting requirements shall be strictly construed against the closed meetings. All discussions, decisions, actions of the board, official business of the board must be conducted in public meetings. The board must accept testimony, provide notice and an agenda, keep meetings, we do that. And they said, tip to avoid a Sunshine Law violation, do not communicate with other board members about board business outside an open meeting. So again, the question then is, what is board business, right? What is construed, which the next page tells us, or on your page, matters over which the board has supervision, control, jurisdiction, or advisory power that are therefore the board or reasonably anticipated to come before the board in the foreseeable future. So if we had all 9 members of the Board of Regents at this meeting, would that construed to be board business, and would they be violating the Sunshine Law?
I think because there's a specific provision in 92.2.5 about attendance at a legislative briefing, we would have a hard time justifying more than quorum. So
Why would you
has
have a hard
So it
time?
literally has a restriction that regents, any board members cannot show up. I'm sorry, let me find it. 2.5.
Oh, that's a board, that's a.
It's a statute, it's in this, it's in 92.2.5.
So the statute.
Yeah, thank you.
I have a copy,
she's a lawyer.
yes,
Yes.
Madam Chair, I have a copy of the entire law here if somebody needs it.
Okay.
Your lawyer. E, 92-2.5.
And read for us.
two or more members of a board, but less than the number of members that would constitute a quorum, may attend an informational meeting or presentation on matters relating to official board business, including a meeting of another entity, legislative hearing, blah, blah, blah.
Relating to though, is that the thing, relating to board business?
Yeah, so this is fine, in my opinion, this is fine.
Right,
Up to a
'cause-
quorum, up to a quorum. But so not, your hypothetical was 9. So
Right.
because we have 11, only 5. Because there's a specific statute on.
But it says in relative to board business, is this
Official
board, official board business? Is the Sunshine Law official board business that is before the board? No, I mean.
Yeah, so
I mean, it's been construed, but again, we read the law and it says board business, because otherwise you can't, people's constitutional right to come in here and hear a bill or understand what's going on, and that they have a right, governmental right, I mean, to do that. So,
I'm gonna look over there
Okay,
and over
yeah.
here, but if you hadn't put Board of Regents and you weren't higher ed chair, then we'd have a better argument. But I think because you're higher ed chair and we had Board of Regents on the agenda, it would be hard to argue that
But
it wasn't
it's
board.
it's informative, but it's not board business. There's never been, I don't believe you've had an agenda item on your board that said Sunshine Law. I mean, I could be wrong, but no, right?
Correct.
So how would that be, how would this be board business?
I would jump in and say, Chair, that, first of all, I think what you're seeing is the level of litigation that is happening right now as a result of Sunshine and UEPA has increased substantially. And what I think you're hearing a little bit is lawyers being concerned about saying something too liberally and then having it bite us, to be frank. It really, I think if you were just talking about, if you were the, I don't know, Transportation Committee, and you wanted to talk about Sunshine, and 11 Board of Regent members showed up and they wanted to talk to you about Sunshine, I think that I might not have a problem with that. Cheryl could, but this is why we call each other all the time. But if Board of Regents, is it actually on this agenda? It's on the agenda as Board of Regents, gives it some level of official business or official activity.
It's the naming of a group of people that I wanted to hear from regarding Sunshine Law. Not regarding any board business, not regarding the selection of a president, not regarding anything that's on agenda, but a state law. So.
Which
again,
impacts the boards, I'm sorry to interrupt you, but I
Yeah.
was going to say, it impacts the board because this is the
but
kind
it's
of
not-
thing.
It says board business, though. It says, and the meetings must be open to the public. And it says construed in openness. This is open. This is an open meeting. It's being televised. It's, anybody can
Senator,
attend.
I don't think there's anything wrong with this meeting that you're holding.
No, I'm using this meeting as an example. That's
Yeah.
what I'm trying to do. I'm using this meeting as an example for all other legislative hearings, which a lot of times they'll invite the board and they say, oh, we can't, only 2 of us can attend, or only 3 of us can attend, and so forth.
I think what they're saying is that they don't know if they're going to end up straying into some kind of board members. So out of an abundance of caution, they would rather make sure that they're not violating the specific requirements of the informational
Well-
briefing statutory provision by having less than a quorum.
But when you say that they're concerned about straying, they don't even have a chance to come because they're being told, you better not go, right? You can't do this, you can't do that. So again, it's,
So I have a question. So is there a law or a bill that we can write to become law that allows the
You
boards to
can,
come?
you can make
as
it
long as they're
clear.
not making decisions,
Yeah.
especially if it's, has to do with legislation that impacts their students, whatever.
Yeah.
I mean, it's, we can't be saying this 3 or 4 times to members of the same board because we're not always going to repeat the same things. So I think it's something that we should look at as far as maybe helping us write a law that is going to be, allow us to have boards before us as long as they're not making decisions at that point. but hearing what we have to say.
I think that's a great idea. And I would take that one step further. When we're talking about boards that are trying to hire executive directors, there's a lot of issues about whether or not they can have those conversations in executive session. And the idea has been sort of put out that, well, we'll have the PIGs, the permitted interaction groups. But what that does is
They're also limited.
lets two people meet with a candidate and then two other people meet with a candidate, but you're not getting the same consistent conversation where we're all hearing the same thing and asking the same questions. And so I think what you've just described is really the issue that we're all experiencing with Sunshine in particular with respect to boards and commissions and their ability to conduct business. And sometimes it requires, in an open session, it's different, but there are times where we have to have candid conversations with one another. We want to be able to disagree with each other, and we want to speak frankly. And you don't want necessarily that process in the newspaper the next day because it'll be construed in some other way. So I love your idea, and I would take it even a step further to clarify executive session and when we can meet or when boards can meet in executive session.
Yeah, we can hope that you can help us with that language, because it seems that no matter what kind of language we put in here, it gets construed liberally or whatever on the side of open, which it is open. See, so there's this anomaly, perhaps, I don't know what the right word is, that says open, and yet these meetings are open. So, how do we then clarify? And then, of course, without, Civil Beat and everybody else saying that we want to, shut out Sunshine out of government, which is not what we're doing and what we're trying to do here. To form a PIG just so that you can get around the Sunshine Law, now that doesn't really make sense, right? I mean,
I would agree, and it also extends the amount of time you need to make a decision. You form a PIG, the PIG meets, the PIG reports, the board discusses it, and then the board takes action. And by then, 7 months have gone by because you meet monthly. So I would absolutely agree with that. We're talking about, I think, two sides of the same coin. We're talking about when can a board be together as a group and speak openly with one another without violating the law, and when can a board be in closed session so it can have conversations that are necessary to just conduct business.
exactly. And when you get so specific to an agenda item, I know I watched an agenda, they said, oh, well, it wasn't put on the agenda. If you veer from this too much, then you can't discuss it, which doesn't make sense, because you normally will have these discussions. You're not making a decision, but you're bringing up possible concerns and issues. With that, I want to open it up to the board of Regents, starting with the Board of Regents. One or two of you would like to speak. I know Neil would love to speak. But, share with us what are the issues, and share with the public, what are the real issues underlining this whole thing.
So far, everybody seems to know what the regents think, except the regents never get to say what they think because we can't talk to one another, among other items. But let me say, and again, I don't think I'm so pleased, we are all so pleased you're holding this hearing, because the general public has no idea, none, zero, about what sunshine means.
So when you were governor, did you have any idea?
No, I didn't have a clue. I wish, no. And you're quite right, I appreciate that. I've been through 36 elections, special elections, primaries, general elections, and thank God this was passed in 1998, so you can't blame me entirely on this one. But honestly, the regents are not here to get into accusations or to get into arm wrestling with the OIP or the Attorney General, particularly because I have conflicts of interest with both of the people that are represented here, because not only was I involved sometimes in appointments and decisions that I made as governor, but because I personally like them so much. So, so let's get to the heart of it. I'm sorry, I disagree with our attorney, which is no news to her. Right, what I have before me, Madam Chair, is Board of Regents legal resource materials for orientation. Regent Akataki and I, the very first day that we were oriented as regents in July, or before July, I guess before we actually got the opportunity to begin decision-making, this is what we were handed. And so the public, I don't know where the cameras are, but this was what we were handed. A good portion of it being Sunshine Law, various interpretations and so on. On that day, by the way, this represents just the police commission hearings and decision-making about could they hire executive directors and so on. This is one case, right? So that's the kind of thing that we're looking at. Now, what I'm saying, I'm not complaining about. I don't think any of the regents are complaining about. What we're saying is, this is absurd. If this is what it takes just to decide whether or not you can hire an executive director, what it means is the law has become, I'm going to say a perversion of itself, but what happens is the law now revolves around itself, and the purpose of the law in the first place has been totally lost. And here's the idea. This is not a meeting of the board that you're hearing. The remarks that you made, Madam Chair, I think are exactly on the mark. I can read English. Meeting means the convening of a board. We're not convening this meeting. You are, and you're not a board. You're a legislative committee. A quorum, for which a quorum is required, not argument, to make a decision or to deliberate towards a decision. This, in the context of official business, a meeting or presentation on matters relating to official board business. We have never agendized as official board business the Sunshine Law in the Board of Regents. Never. Part of the reason that we can be here today is not only have we never had it as official board business, not only have we never and are not now engaged in making a decision or deliberating towards a decision with respect to the Sunshine Law, but we are in an argument. I shouldn't say an argument. We have a dispute with our attorney who's trying to protect us. She's the attorney for the Board of Regents and for the UH administration as to whether or not we can come today. The irony of this is, and I say this to all the members of the committee, the irony is 11 of us cannot come today according to what our best legal advice is because of the Sunshine Law, to talk about the Sunshine Law to you. It's absurd in its face, and I'm not saying it in order to try and say, aha, we caught you or anything. This is not a meeting. There's no official board business. This is a hearing of a duly constituted committee of the Hawaii State Senate, of which I had the privilege and honor of serving on at one time, for a public university. We have, and according again to the laws that Kerry was good enough to explain to us in detail, we have jurisdiction and responsibility to oversee the university in terms of its operations and in terms of its requirements for capital improvements or whatever it is. In order to do that, in order to be able to answer your questions or make observations to you with authority with regard to the university, we need to be able to talk to one another. If I can, I won't go further, other than to say, I believe all 11 of us should be able to be here today with no question. If somebody wants, or some group wants to question whether the 11 of us can come to answer questions or make observations at your request, then they have an agenda of their own that has nothing to do with the Sunshine Law and certainly inhibits the work of the Board of Regents. Okay. Give you a very quick example, and I'll back down. I bring it up solely because it's been a subject of common conversation in the legislature and in the public reason. Student housing at the University of Hawaii and Manoa. When Lauren and I were first came on board, Warren was made, I'm overjoyed to say, the chair of the audit committee. And what she decided to do, by the way, the audit committee was put into law by the state legislature. This isn't something the Board of Regents made up. This is law, that we have an audit committee. The difference is that Lauren Akitaki decided, well, she's the chairman of the audit committee, she's going to start looking into it, what the audit committee does. And one of the first things that came to our attention was student housing, both from students themselves and parents and so on and so forth. So there were two of us. And I want to say, Carrie has, I want to put it on the record, Carrie Okanaga has assiduously, religiously coached us in what constitutes obeying the Sunshine Law. We did that, I can tell you that. We contacted the university to go and see about the student housing. And this relates to a question that Senator Kadani said. When you said, we can't do this 3 or 4 times in order to inform the regents, you have to do it 6 times. 6 times. You have to have 6 separate meetings, 2 regents each, and two regents through 5, and the 6th one is one-on-one. To conduct any meeting, to conduct any information sharing. And you can't do the 6 at once. You have to make sure, for example, if we had the 6, we could not be as close, Senator Kadani, as you and I are right now, because you might overhear something that's being said in terms of information, like it's being exchanged right now. None of the regents, the 3rd regent couldn't do it. So there's just the 2 of us. We go down to see the student housing, okay? The vice president in charge of housing recently appointed was there. The head of facilities management of all the facilities at the university was there. The head of student housing was there, because there was just 2 of us. If other regents had come, those people who know everything about the student housing couldn't talk to them. They could take us around, then they'd have to come back, get the next 2 regents and the next 2 regents. I suppose it would take all day long. I ask you, just think of your committee. If 2 of you could come, but you 2 on the end, no, you got to wait 20 minutes or whatever it is, just to get basic information.
Is that what's happening? I mean, if they go on a tour, they got to split up 2 by 2s?
There is a provision that I don't have in front of me. I'm sorry, I'm gonna look at for site inspections or field trips.
There's a limited meeting provision. It doesn't require just 2 people at one time. You can have the whole board go on it for certain reasons. If you meet the requirements for limited meetings, one of which is to take a video or audio recording of your meeting, then you can have the whole board go to view something, like you could go
I'm sorry,
on these
wait,
things.
I'm sorry, but what did I just get through saying? This isn't a meeting. It's not a meeting.
No, but we're talking about a site visit, right?
Right, you can go on site visits
So the
when
site
it's
visit of the
necessary
housing-
to meet at a location that is dangerous to health or safety, or if it's necessary to conduct an on-site inspection of a location that is related to the board's business at which public attendance is not practicable. And I concur, and I'll often concur, as long as you meet these requirements, then you can hold a limited meeting at that location that's not open to the
Okay,
public.
but they're not holding a meeting, they were just
Well,
going
what-
on a site visit and getting
That's
information?
considered a meeting, though.
You see, that's where
Okay,
look,
A meeting is exchange of information and words. If they just shut their mouth and go and observe, can they all go?
No, I don't think that would really fly. I mean, because the thing is, if you're gonna get
I
together.
rest my case. I rest my case. No, please, Carol, you know this. I don't want to arm
Yeah,
wrestle with you,
yeah.
right?
No, I
look,
understand where you guys are coming from.
It's been 25 years that they've been trying to implement this. I'm sure the decisions that were made, all of us, especially, look, there's no rookies on sitting here, right? Have made decisions that at the time seemed, okay, this was the right thing to do, and maybe it was at that time. But over time, then, circumstances change, situations change and so on. You need to have a little flexibility. What I'm saying is, the definition of a meeting that you are struggling with, And right now, Cheryl, you were struggling to try and say, how is a limited meeting or not a limited meeting? No board or commission should have to struggle with themselves to decide whether at any given moment something is a limited meeting or not a limited meeting, because there are people out there with their own agenda. No matter what decision we make, no matter how sincere we are, no matter how much we are not making a decision or deliberating, are gonna say, yeah, that's what you're doing. And the next day in the paper, what you have is Regents violate the Sunshine Law.
So
And there you go.
let me put this forward. So we can have, say, 4 members of the administration in any situation. Talk to a regent or 2 regents or a member of a board or 2 members, and you can lobby that member and you can kind of tell them what it is you want them to vote on, right?
Yep.
Well, this is really good. You got to support this measure. You can go and you can talk to all of them, and you can talk to every single one, and you can tell every single one of them the same thing so that they come together in the meeting and they make that decision. Now, is that sunshine? I mean,
That's permission.
that's permitted, but.
Because
but
they're
they
not,
get-
the sunshine law applies to the board members, not to the staff.
No, but the fact of the matter
So that
is,
they can't-
the sunshine law is supposed to be where it's
But it's,
open.
as long
and
as
these-
it's not
let me
like a
finish.
board member telling them, using that staffer as a means to
Okay,
get
so
the
then-
same message.
No, that's not
So
what was
then,
asked.
so then, the sunshine law should apply to the administration as well, because they can come together as a group with no limitation. They can approach every single board member and say, we want this person to be your next leader. Unbeknownst to everybody else on the board, who is supposed to make this decision in open public and not talk to each other, don't know that they've already poisoned everybody, I don't know poisoned, but got everybody and lobbied them. So now a name comes up and the decision was made in the back rooms unbeknownst to everybody else. right?
Theoretically, it could be the administration, it could be a special interest group. It
Exactly.
could be anybody who's not a board member,
Exactly.
theoretically.
Theoretically, and
Yeah.
that's a problem, because the whole issue of sunshine is to allow them, now, if they could talk to each other, they would know that somebody is trying to manipulate all of us into making a
We
decision.
we could not do that because we can't talk to one
Right, we
another,
can't
so
talk
we
to
will
one
never know.
Okay, let's hear from another board member. You have a different perspective.
I'd
Okay,
like to follow up on,
can you give him the mic?
Oh, yeah.
like to follow up on a few things. First of all, what Neil was talking about, say, going on a tour and we're in 6 different groups. We all get we all get different information depending who's giving us the tour. And so that's one thing. And also what the state AG had mentioned about the, at least having the ability to go into an executive session when, I guess, reviewing candidates, because when candidates know that their resumes are going to be in the public or their names are going to be public, it definitely reduces the quality of the candidates just because, they're working someplace else. And even the Sunshine Law, we can't even be all on the same email. That's right.
Well, you can get it from the staff.
Oh, yeah, but we can't, if we want to respond and everybody else is on that.
This is a discussion
Yeah, we can't,
outside of a meeting.
yeah, so we can't.
Can I interrupt on that? So I sent an email to 4 of the board members. Can't send an email, sharing with them an article in the paper about, I don't know, board across the country, how boards are having a hard time governing. So now, if they forward that to the rest of the board members, that's not allowed.
Depends on what they say in that email.
They're not saying, they're just saying, this is from Senator Kim, forwarded this,
As long as it's not being construed.
But they were told they
as-
couldn't do
as-
that.
As, it's not being construed as, this is my point, this is what I believe or I oppose, and I wish you would consider it.
Because I recall,
Because we've had,
I recall hearing from the board saying, you sent us this email and we sent it out, got in trouble because we weren't supposed to.
yeah,
I
but
guess
out
that came
of
from.
abundance of caution.
But
and
again-
I understand them, they don't want that kind of accusations to be leveled against them, so they just say, don't do it. If you're gonna send an email, do it to the staff, then there's no question that this is not you trying to influence other board members.
So if
You
I
can
have
send
any,
it to everybody if you want, there's no restriction on you, but it's when
So I can't send it to the chair and say, I want you to send this to all your board members. You can't do
Well,
that.
you can, and the chair should be sending it through the staff, say, please distribute this to the staff.
Yeah,
to the-
I can't say, is someone going to follow up on this if I send it to all the regions?
Yeah, because there have been actually a Supreme Court case, Hawaii Supreme Court case, about these kinds of communications between board members. So it's not just us.
Let me have Regent Tochiki and then I'll follow right after.
And I wonder too, if you did that and you sent it to, say, 4 members and none of us responded because we can't, right? We can't even say thank you because that becomes,
Well, no, you
Business.
can say thank you, and you can talk to her directly, but you cannot talk to each other. The
But not
Sunshine
to
Law
the 4
regulates the behavior
people.
between board members, not with non.
Okay, so
Wait a minute, but saying thank you on the same email that she sent to 4 is a violation?
and that may be that's,
No.
but if I maybe commented on it.
Yeah,
If I
commented,
commented on it
saying,
or pre.
I agree, I
Yeah.
wish everybody else would consider this, no, that's a different message.
Because then that's 2 more
Then
than.
you're sharing, you might be commenting on.
So
what if no
one wants to serve?
And let me just.
Chair,
If I could-
can I just also add, the expressions on your faces and everybody else's is exactly how we all feel. Because trying to
Why
understand.
haven't we had you folks, the legal people, come and tell us what are the pitfalls and how we can change this?
Well, trying to get changes to Sunshine or UIPA is a losing proposition with the legislature. We can't get bills heard. Last year, the DPP, the 720,
Deliberative process privilege.
it was killed because that provision was in there. And the purpose of the deliberative process is to allow, let's say there's a board that is trying to make a decision and they have materials and they talk about it in executive session. The deliberative process keeps those materials confidential until after the decision's made. So right now, there's a Hawaii Supreme Court decision that could make those materials available during the decision-making process.
Reggie, bills die all the time.
I know.
Keep introducing bills until they pass. So let's not try to predict the future and be naysayers that we can't get it done. We need to keep trying and educate the public as to what is going on and having these things refined. So I promised Senator he could speak, and then I want to hear from John Comagio.
Usually it's better that she let me speak now before I blow up. Anyway. The thing is, what I don't understand, and I was on a neighborhood board long time, yeah? And we changed some of the provisions within the Sunshine Law because we could not effectively do good for our community if we couldn't communicate. So Neil, you think a lot of things that are lacking on the university's campus is because you guys cannot do your guys' jobs properly?
If you're asking me, and I dare say I speak for everybody, the answer is an emphatic yes.
Okay, because that's how we started being more effective, is when they changed the limit of when we can go to, we couldn't even get sweared in before together that to do individually, because we would break the Sunshine Law. But it had to be changed, and they changed it at the city. I'm not saying it's that easy here, but you have pretty much everybody here that is in agreement. But if we're not gonna do something that's gonna be able to make you guys do your guys' job efficiently and help you guys have the tools, then it's hard enough we'll tell you guys what you guys did right or wrong if we're not giving you guys the tools to do your job.
May I, Senator? Not only are you exactly correct, remember today, somebody told you were exactly correct, right? So, look,
We tell them that all the time.
But the precedent is already there, Senator. The precedent is already in the law. Under 92.6, number 2, A through G, are boards and commissions which are exempt from the Sunshine Law because they're unable to do business otherwise, including the Board of Trustees. All you have to do is substitute the word Regent for trustees, the Board of Trustees of the Employment Retirement System. Now, how come the employment retirement system trustees can talk with one another, but the Board of Regents can't talk with one another? In order, I'm not, when I say talk with one another, I'm being very specific about it. And Carrie understands this, because we say it over and over again. We're saying talk with one another, not deliberate, not ask people how they're gonna vote, not deliberations or anything, just information sharing. Case in point, when I just came in as a regent in July, the Division I football conferences were blowing up all across the country, including the conference that the University of Hawaii is in. A sports writer in the San Diego Union Tribune wrote a summary in a sports column, a summary of what he thought was going on at the time. Not saying anything that should be done, you know, making a decision or delivering, simply, here's the 6 or 7 things that are going on with Division I football right now. I thought it was a terrific summary. And in my naivete, I thought, well, this is something, and maybe the rest of the board would be interested in. So, on my own, without conspiring or getting up in the morning saying, I wonder how I can screw the Sunshine Law, I said, well, I asked my assistant, copy the sports column from the San Diego Union Tribune and send it to my fellow regents, FYI. FYI. Not I'm for it or I'm against it. In fact, the column itself wasn't for or against anything. FYI. Oh, did I get read out? Boy, I mean, I was told that, don't ever do that again. You have to go through the staff. And I said, why should I go through the staff? I'll send the copies to the staff next time. As long, and the regents too.
So you cannot just FYI something to
No,
anybody?
you cannot.
I'm asking.
No, wait. I don't know that, Anna, that's not true. I'm not trying to say, aha, you see, I caught you. I can't even send an
No, I know, I'm just
FYI.
asking.
What I'm saying is the Sunshine Law over time has lost its way. I understand the purpose of transparency. What's more transparent than sharing something that you think everybody should know publicly on an FYI
But see,
basis?
that's an interpretation again, and everybody's been trying to interpret it so liberally and cautionary and trying to protect you that they've gone too far.
I agree, but this, and I'm sure you agree, I've been there and you were there right now. And Carol has been in two different legislative bodies in this respect, the city council having to deal with this and right now. I couldn't agree more about that. All I'm saying is we need to be enabled then to be able to come to decisions, that's all. I'm not asking, excuse me, not me. I don't think we're asking to overturn the Sunshine Law or anything. What we're asking for is at least the capacity that these other boards and commissions have. The Ethics Commission, the Victims, Crime Victim Compensation, Board of Trustees of the Employee Retirement System, Civil Service Commission, Labor and Industrial Relations Appeals Board, the Hawaii Labor Relations Board. I cannot conceive that these various boards differ that the Board of Regents' responsibilities and authorities differ so much from these other boards that we couldn't qualify.
Okay, John,
Thank you.
representing the monarchy.
Yeah, well, I'm not, that was my caveat, that this is gonna be, like Carrie said, we've not deliberated and talked about this as a board, so this is kind of my own observations. So I want to start from the point that my own observation in terms of Mauna Kea as an issue. Part of the problem, and I'm not casting blame on anyone, is that communications broke down, right, between all these various stakeholders. So that's why we're kind of at where we are today. So one of the things that we're trying to do as a board is to increase communication. But, weird way to some of the points that have been raised, the Sunshine Law is kind of prohibiting us from increasing communication between the various stakeholders. So our situation is a little bit different from theirs in the sense that the Mauna Kea Authority, we're standing up a brand new state agency, as all of you know. Until September, we had no employees. So what that meant is that individual board members are working board members. We had to go hire, the board members have to go hire our executive assistant. I mean,
So you couldn't talk to one another, you had nobody to send the email to pass it out to the rest of the members?
right, that's one of it, but our board is actually working because we have no staff, so our board has started to meet to try to create a master plan, to create a communication plan, to do community outreach, but we're kind of hampered by sunshine because only two of us can talk at a time. We cannot have a conversation between the three of us, so part of the challenge, and when you're trying to work and create something and you cannot talk to each other, makes it really, really difficult and slows down the process. Now, the legislature has given us 5 years, and we've used it up half a year already. So if we are strictly bound by the sunshine law, it's going to take us a lot longer to get to where we got to get, right? And I agree that for the 6-day agenda and that matters should be fully discussed. I also agree that if we are allowed to have conversations, that we should not be soliciting votes or arranging votes, that there should be full and complete discussion on any issue in a public meeting. But to hamper us by saying that you can only talk to one other board member at a time is really, really hampering us, especially in the working group. The second part of our issue is that we're dealing with a highly emotional issue with many different stakeholders. Part of what I've discussed with individual board members individually without breaking sunshine is that there is no problem-solving platform that says you can only talk to one side at a time. You cannot solve problems if I can only talk to them. And the legislature in its wisdom created specific representatives of each of the stakeholders on our board. Generally you would, to try to problem solve, you bring two different perspectives and then we have a discussion or whatever the perspectives are. But from a cultural perspective also, we've been told that a problem-solving platform like Ho'oponopono doesn't artificially limit you to talking to one side at a time. So again, we've not gotten to that point, but we foresee that as a problem as we try to kind of talk among ourselves about how. One concern that I've heard is that, people going to believe that somehow you are trading votes. No, we agree that in our discussions outside of a board meeting, we should not be soliciting votes, trading votes, et cetera. We should have full and complete discussion, but we're not even allowed to have any discussion. So anyway, that's our situation is just a little bit different from theirs, but we are constrained just as they are in terms of either problem solving or trying to build this new state agency from ground zero.
Carol, did you say anything?
I wanted to ask our AG if there is a way around this discussion to be able for the board to send information to each other without saying this is how we should do it or I need your support on this, but just FYI. Really, is that saying that you agree or you disagree with whatever you're sending?
I know there's a solution and my staff is going to hate me, but we will have a bill to you before the end of whatever our deadline is on these things. I'm happy to do this. And just so that you're aware, it's not just these attorneys making these decisions. The Hawaii Supreme Court regularly, liberally construes everything. And so we're constantly trying to interpret their 50-page decisions where they take things apart. I'm sorry, go ahead, John.
I was going to make the question to me is like, if you send something FYI, what if you send something out that says, here's a good article for you to read?
You're saying it's good.
That's what I mean. So
can't
that's
do
a
it.
violation of sunshine.
That's
Because
But
you,
that's why I'm saying, if it's just FYI, it's better than putting the word good in
Good, yeah.
there, but at least, did you see this? Something like that, I mean,
You're not saying. I
But even
support
for a
it.
hearing note, because of this concern, even the hearing notice for this thing, I gotta send it to our new executive assistant that came in September, and he sends it out.
So you cannot make any smiley face emojis? like
No.
that, no?
You're right, you can't do it.
One other thing we were told with the emailing is that even if you just say FYI or you don't say anything, you have to, the staff BCCs everyone. Because if you put everyone's email address and they reply, then you're now communicating with everyone. So that's how the staff communicates with us, to BCC, to avoid someone replying even, to start a conversation.
Chair, I would agree that this bill has become its own monster over the years with all the different interpretations. I think everybody here will tell you, I absolutely believe in transparency. I absolutely believe in it, and we should be transparent as much as we can. We also need to run a business, whether it's a board, whether it's the Board of Regents or Mauna Kea Authority. You have to run a business, and that requires the ability to have conversations. And again, I think they may have groaned, but there are already some bills that have been prepared. There's one, 719, I think, or 7 something, that may still be in the session from the first year of the biennium, but
We gotta start fresh, because these bills somehow never gets reheard from carryover. But, in addition to having a bill, there needs to be public education, so people understand that it's not, we're trying to be devious or trying to get around the Sunshine Law in practicality. And then we need to make sure that this information that is provided to this committee gets provided to the committees that will hear the measure. Because, it can't just happen in a vacuum. You introduce something and it keeps dying because for the lack of information, the lack of understanding that, how it's applied. Because I'm sure a lot of people don't realize that you can't send something FYI to everybody. When I heard that from Neil, I was like, what? You can't send something? It's crazy. Yes, Karen.
Senator, I just wanted to add on to what the Attorney General was talking about the litigation, the increase of litigation and the fear that strikes, especially in non-lawyers, lay people. I mean, lawyers in and of ourselves, we don't like being sued either, but because of the increase in challenges to the boundaries that were long existent, everybody found a way to make it work. It has led to some of this more conservative outlook, because you have to end every sentence. You might be sued by one entity in particular has seen fit to, try to push those boundaries and.
But we've enabled them to do that.
Pardon me?
We've enabled them to do that by being so liberally construed to the fact that when you're not that liberal, then they're gonna say, well, you did it for this, you didn't do it for that. or
Right.
whatever.
well, Chair, the Supreme Court has certainly helped that process
Yeah.
along.
And
Sorry, and there-
unfortunately, we confirmed them, so that says.
No, and the language that Cheryl talked about in terms of the purpose, they use that language to say everything should be in the open, you shouldn't
But it
have
is in the
conversation.
open.
No, but I mean, that's typically why we lose, is because the standard is against us from the beginning, government, anyway. And then the other thing I wanted to add is, we have had a sunshine law in exec session on the agenda, exec session agenda, because we are in the process of a presidential selection process. And that has been the
But not-
subject most recently of one of those lawsuits that we're talking about. So it's another area where, honestly, I've been doing this for, too long, but it's impossible.
Cannot tell.
It's impossible, you're so kind. It's impossible to give advice, because you have
What if we
OIP
leave-
advising that it's proper, and then you have a lawsuit that says it's challenged. The lawsuit may be dismissed, the AG is going to represent admirably, but at the end of the day, these are lay people
Why don't
who
we
have
apply
volunteered
the
for
Sunshine
their
Law, write a
service.
law, apply the Sunshine Law to the judiciary as well as to the media. Administrations of college campuses, whatever. Why don't we apply the Sunshine Law? across the
Chair,
board?
I'm sure none of us have ever said that facetiously.
Until you do that,
Yeah.
it's like,
You know, the thing that it bothers me is that when we was growing up, yeah, and we come adults, yeah, we try to be trustworthy in doing the job and the mission that we are assigned to. And that's something that I learned from my mom and my dad. You know, you kind of go outside the scope, even though sometimes I go off road, but we're here to do a job, and we're doing a job for the university. And we should be, I use that word, adults about it, and do the job of the university, because the only people that's hurting is the kids and the community and the taxpayers for the university. So, you know, just the same, if somebody say that, I don't know who's suing us, we're adults, this people be an adult. But it's just sad when I'm hearing this kind of stuff, because there's no way that we can do our job as legislators and any other boards. I mean, I was looking on top of here, somebody supplied the police commission, got the neighborhood board, county council, nobody will be able to do their job. So why are we handcuffing them? I don't understand, Chair, and I'm still new, so I want to learn this, so we can help.
You know, well, because we passed those laws based on people coming in and asking us for certain things to be included. Stuff get included at conference at the last hour to get something to pass, and then it gets liberally construed and interpreted. So
Okay,
that's
so-
why we're here.
So this is the new age, so we just put body cams on everybody?
Right.
So Chair, I'd like to say that the executive branch has shot itself in the foot repeatedly, though. There has been improper behavior. There has been graft, there has been these violations.
No matter how much laws you
Right.
pass,
So every time something happens, the reaction is we have to make it more transparent. And so as a member of the cabinet, and it's my obligation to hold myself and my department accountable and to be transparent. And you should hold me accountable in the same way, as opposed to what I think has happened, which is to try and pass a law to stop these
But when we
things.
do that, then we're called bullies. When we try to hold you guys accountable, we're called bullies, right? And we're trying to, manipulate you guys.
Well, this all goes back, let's circle back to where we started, which is the Sunshine Law itself. And again, I may sound like a broken record, but one thing I've learned in politics, it's the obvious you have to say over and over again, because you take it most for granted and forget first, right? And what the obvious thing in here is the definition of meeting, and what the definitions
business.
are with respect to making a decision and deliberating towards a decision. If all we did was recognize this is representative government, Regent Henning, Bill Henning, put his finger right on it the other day when he said that our work isn't a plebiscite. And what I use, it's not a referendum, this is representative government. All of you have been elected by the faith and trust of your constituents that you're going to use your best judgment to act on behalf of the people of your district, the state of Hawaii, and in this instance for us, to act on the best interests of the University of Hawaii, to our best judgment. Nobody's claiming, certainly none of the regents that I've been associated with, I'm happy to say for these 7 months, thinks that they're the beginning and ending of wisdom, or that when they get up in the morning and look in the mirror, they don't have to look any further. Not that I know of, but this is representative government. You have to assume not that we're conspirators, not that we wake up in the morning thinking, I wonder how I can undermine the University of Hawaii today to my own interest. Quite the opposite. You have to assume we're going to do the right thing. If somebody's going to do the wrong thing, they're going to do it. The Sunshine Law has been in effect since 1998. And to the degree or extent.
Before that.
Pardon?
1975.
Well, but I'm talking about the version that has the latest.
1975, you were a legislator.
Yeah, that's right. Exactly right. I was a rookie. I remember somebody.
Not that I read about.
But I remember somebody said to me one time, in a congressional election, where I made some comment about something, or took some stand, and a newspaper reporter said, You didn't say that 15 years ago. You said the opposite 15 years ago. I think it was on term limits, right? And, well, there ought to be term limits or something. So, well, you've served 4 or 5 terms now. What about term limits? I said, I changed my mind. Which is right? I mean, you changed your
You
mind.
listened to testimony and it made
Yeah,
sense, and you
I
didn't
listened to
realize it.
testimony.
You
People
changed
were
your
telling me you're
position.
doing a great job, Neil. Run again.
And they changed their mind.
All I'm saying here is, honest, the people who come with their lawsuits, the people who complain, they've all got an agenda. To my knowledge, maybe Carrie, and maybe you know, Ann, I mean, you certainly know. To my knowledge, no individual who's brought a lawsuit or is complaining, no group that's done it obeys the Sunshine Law. They all operate without the Sunshine Law inhibiting them getting together and talking it over, whatever they want to do. So all we're
They can
saying
get
here,
records from us and we can't get records
I
from them.
beg your pardon?
They can get records from us and we cannot get records from
Yeah,
them.
I mean, I don't even know how some of these people, they say, oh, you represent a public interest. I don't know how they get elected. I don't know how their boards are chosen. I don't know what kind of financial arrangements they have. I don't know, none of it. These groups are all opaque, right? And the press routinely, just make one complaint, the press routinely cites somebody as a nonprofit group that represents the, so far as I know, the press never goes to see, well, who funds these people? Where do they get their money from? How does it work? Do they have a special interest that they're pursuing? I think that a lot, today now especially, a lot, and some of the things that we're facing as a Board of Regents right now come from groups whose interest it is to create drama. That's how they get their membership. That's how oh, it's a crisis. Oh my God, the state legislature is made up of bullies and saboteurs
Right, and we
of
try
the
to tell you
public interest.
how to run the presidential.
Believe me, there's no more transparency in the world, and I'll rest my case on this, with the presidency, the choice of the presidency. I'm sure all the regents agree that the most important decision any of us are going to make while we're regents is who's going to be the next president of the University of Hawaii. That has all kinds of implications all over the place, economic, social, cultural.
Okay, I'm going to stop you there because you might be violating the Sunshine
Oh.
Law.
No, this isn't a meeting. Well, I can say, my view is I can say anything because this is not, we're hearing.
I know, I'm
This
saying
is a
that
hearing.
to make a point.
Well, all I can say, I can tell you right now, that it is public record, that right now, what the regents have done, talk about transparency, you talk about openness, you talk about desire to hear from the public. We have in writing right now, over 1,300 responses from faculty, from staff, from citizens, from alumni, everything about the presidency and what they expect and what they want. What's more open than that?
And for the record, I haven't submitted anything.
But you can.
And then I'm going to be
And she's
construed.
not in the running either.
And let me tell you, that has nothing to do with deliberation. It has nothing to do with making a decision. We're not forcing those people to get in touch or anything like that. So we have no meetings on it, nothing. All I'm driving at is that, all we're asking is that that the idea of a meeting, the idea of making a decision, the idea of deliberating be separated from acquiring information, gaining perspective, filling gaps of knowledge that you might have or not have. And that's all. And then rely on your committee structure to be gathering information. Then we're only too happy to come to a meeting that is that has an agenda which has the subject matter before it.
No, even then, though, they don't come. Regent Tuchiki.
I want to add just a thought, because I am so proud to be a part of the Board of Regents. And oh my goodness, what a group of very strong people who I think very sincerely want what's best for our university. And we've been asked to do some tough things. And there are some tough situations that we need to address. And if the only way we get to do decision-making is with the agenda and the testimony that comes in without being able to get out there and ask the questions and confer with one another, we're not going to be able to do the tough stuff. So that's what we're asking of. And I agree, the selection of the president is one of the most important things we're going to do, and we are going to do it openly. I don't know how you craft the perfect balance between what we need in open government badly and having, like Senator Gonzalez said, the tools that we need to get our job done. And so God bless you for doing that. You know, there's got to be a way. There's got to be some trimming that can happen. And I really appreciate this opportunity to share.
I just want to say this has been one of the really open meetings we've had. No, I'm hearing from everybody, and everybody's speaking their mind and not being afraid that we're going to get quoted or we're going to get, bashed in the media about this. But this is real things and how it affects how we govern and how we address issues and needs of the public out there. And so it needs to be done, and it needs to be done more than just my committee. And I had to limit it because, like everybody else, there's rules of purview. And so my purview is not the entire Sunshine Law, but it's how it relates to, the University of Hawaii, related entities of the University of Hawaii. But your bill will be probably taken up by a different committee. But then we have the duty to be able to talk to that committee and that chair as to some of the things that went on here.
Senator, I gotta say, this is a very different kind of hearing than I've been sitting in on for so many years, because you don't hear this kind of perspective at most of the legislative hearings.
Yeah, well, it's
So-
hard when you come up there and you deliver your thing and you sit back and somebody else come up and sit back. You cannot have this kind of under that format. And this
Right.
is why I've had folks.
And then what you hear a lot of times is the public's distrust. They
Right.
do not trust
Right.
the boards. They do not trust politicians. They do not trust the people in power, which is why they want all these guardrails in the law. And over time, it's been maybe strengthened a lot more. And, to the point where you're starting to
Strangling.
micromanage the boards, and it gets really hard for the boards. It is difficult. So I understand where everybody's coming from, but I also understand how we got here and why we have these things. But I hope that the legislature will be able to strike a better or right balance for everybody concerned, because you guys make the law. We only administer what you tell us to do.
Well, so we're gonna, yes.
I just want to follow up what Cheryl just said. The level of distrust hasn't improved within the public, hasn't improved with Sunshine, right? So it's not accomplishing what it's intended to do. If the idea was to create more trust in boards and commissions and city council, if the level of distrust is rising, it means it's not doing what it's supposed to do, right? So we've got to take a look, or you guys have to take a look to see how can we accomplish what we wanted to accomplish.
Okay, so we're going to, Carrie, you wanted to
Sorry,
say-
just really quickly. I think big into roles and responsibilities. So the voice not here that usually comes into those meetings is the media or
Right.
civil beat or
Well, this
whatever.
was
And
open
we
to
are-
them, they could have been here.
We are, none of us are saying that government shouldn't be, transparent, but we also have a job to do. And to expect us to do it within the constraints that a certain law center believes we should is very impossible. It is literally impossible. And I'm like a problem solver. I believe in navigating this situation that we're in. And I would say that the institutions have lost trust, not just government, media as well. So I have worked a long time in government. I have met far more good people than I've met. I mean, honestly, the very few that the media portrays as the people who did bad things, the vast majority of government officials are good people. And we have these restraints on lay people, boards and commissions, to try to get, the work of the people done. Yeah,
Well,
I
the
think we lost our
legislature
way.
has a tendency to want to legislate for one individual sometimes, two individuals, small groups, which is really not what the law is supposed to be. So part of that is our fault. Yes, Regent.
Yeah,
Wilson.
Ernie Wilson, and along with Gabe, the vice chair of the board. And I've been on the board the longest of any of the regions now. I'm in my 9th year. And one of the things I learned many, many years ago from my kupuna, but also as a young second lieutenant in the Army, is that you need to build trust, and the way that you build trust, and going back to what John just said in terms of trust has not been, Sunshine Law has not apparently done that, is to really demonstrate by being inclusive. And one of the things that I've said in meetings as we talk to the presidential search, because Gabe and I have been tasked with being probably a strong part of that we need to be inclusive in terms of including all of the constituencies and listening to what they say. And I think, we're proving with the survey, we're getting ready to have meetings with the major constituencies, say, your voice is important. And I think this, you're demonstrating that by having this hearing and saying, hey, how do we solve this? Because I'm here to tell you, I've been on Mauna Kea when we formed the first PIG. We decided to call it MIG. So we had MIG 1, MIG 2, and MIG 3, just because of the Sunshine Law. And, we just really couldn't have the kinds of discussions that we needed to have when we're addressing the issues of Mauna Kea.
Thank you very much. I want to thank you all
Just one-
quickly.
Yeah, right.
They're going to cut us off.
No, yeah, in with respect to the priorities that you folks established yesterday, both the House and the Senate, obviously, the Maui fires have caused a central focus and priority to have to take place. Our difficulty as regents right now is we can't help. If the Maui fire happened today, we can't take it up and talk about it, even in an open meeting, because we have an agenda, put it on an agenda 6 days in advance. The University of Hawaii, in terms of Maui College and the community college over in Maui, is a terrific resource for whatever legislation and activities the legislature is going to be pursuing. But for us to aid and assist you in that, aid and assist the people of Maui, as a board, we're hamstrung right now because of what the Sunshine Law is doing. So all we're asking here is give us an opportunity to be able to act as responsible adults. Give us a chance to act as responsible regents. Give us a chance to establish in the public mind trust and faith, because we think not only that we can earn it, that we are earning it, are capable of earning it, and want very much to have that opportunity.
Well, I want to thank you all for coming today, and thank you for speaking out and expressing yourself and sharing that information with us. I hope that it was productive, and look forward to the Attorney General to come up with a bill or several bills. But in the meantime, I would like to ask the legal minds that are the ones that are liberally interpreting this and liberally talking about what a meeting is and what board business is, that you really look at some of the things that you have been doing in the meantime, because everybody needs to be able to do the work of the people and to be able to do that openness and make decisions openly. And obviously, the things that are coming up, they're not making decisions. So I ask that you folks do that. And hopefully during the session when we have the bills, we'll be able to come back together. But you all also have the responsibility to inform and let the other legislators know that this is a concern and educate the public on that as well. Okay, with that, if there are no other business, we would like to adjourn this meeting. Thank you.